This week on Lewis on the Law, we've got another great show for you guys, so hold on to your seats. We're going to talk personal injury with attorney Marlon Rhine of the Rhine Law Firm. You are listening to Lewis on the Law. My name is James Lewis, and I have got another great show for you guys today. Once again, this show is all about empowerment. We're here to bring you power and information. It's not designed to replace the advice of an attorney. If you have a real legal issue, you need to go ahead and contract with an attorney and not just listen to my show. Now, I've got an awesome show for you guys. I am excited to have attorney Marlon Rhine in the studio with me. Marlon is a personal injury attorney with the Rhine Law Firm in Decatur. So we're going to talk personal injury. The scenario is, you've slipped, you've fallen, you just can't get up, you've hurt yourself at a business. What do you do? These are the type of questions we're going to get into in just a minute. So first, Marlon, tell us a little bit about yourself. Where's your practice at?
Sure. My office is located over in Decatur, Georgia. We're right next to a very good donut shop in what's
a great donut. Wait, what's the name of the donut shop?
Revolution Donuts.
Oh, okay. I love that place. That's awesome.
It's dangerously close, and it's within an area we call Homer Simpson Plaza because it's donuts, beer, and pizza, and also really good Lebanese food as well. So kind of an interesting blend there.
The Lebanese food doesn't really mix in there, does it?
I tell you, it's good for lunch, and then you can kind of, you got donuts for breakfast, and you got the pizza for dinner, and beer for the weekends, right?
Nice, nice. So we're talking personal injury. So what type of personal injury are we really talking about here? Just any type?
Sure. So our firm specializes in doing, motor vehicle accidents, trucking accidents, premise liability work. So that's like trips and falls. We do a little product liability work, and those are the practice areas that are in our wheelhouse. Presently.
Okay. Well, that sounds interesting. So, what do you? So, what are your first steps in an injury? I mean, let's take a supermarket slip and fall just to give an example here. What are your first steps in an injury situation?
Well, the first thing that you want to do is, this may sound very basic, but you want to make sure you're okay. First and foremost, get up if you can, and check yourself out. Make sure
you mean you're
not physically
supposed to lie
all right
there and wait for the stretcher.
Right. I know, counter to popular belief. So obviously, like a premise liability case may be a bit different. I was assisting with a client with a case recently where she fell and damaged her face very badly on a curb due to a broken piece of cement. And in a case like that, basically, you need to sit, you need to wait, you need to not move too much, but call the paramedics and make sure you get proper medical care. You want to go to the hospital or wherever else that may be closed. That may be an urgent care center. That may be just calling 911, going via ambulance. I have some clients who want to get to medical care faster, and sometimes a spouse or a close friend will take them, and that's actually faster than calling an ambulance. So in a typical premise liability case, that may be what you want to do. But you also want to do is take pictures of the surrounding scene. If you fell on something in particular, you'll want to take pictures of that. And in this day and age, it's really easy because everyone has a cell phone that takes pictures these days. Exactly, and that applies to motor vehicle accidents as well. Of course, the approach is going to be a little bit different. In a premise liability case, you may want to call for management or someone that can make a report of what's going on. In a motor vehicle accident, it's somewhat similar from a report standpoint in that you want to call the police. After you've made sure you're okay, call the cops. And whether you're at fault or not, that accident report is going to provide really valuable documentation of what's occurred. Then, of course, like you said, having a cell phone in this day and age, it used to be that people would keep small disposable cameras in their glove boxes. But now with a cell phone, there's really no reason to not take pictures, assuming that you're physically able, if it's not that serious of an accident in that you're able to get up and move around. Of course, if the car is severely damaged, you need to do whatever you need to do to get to safety, whether that's move your car or stay put, depending on how severe the collision's been. Okay, so is it okay for a person then to take themselves to the hospital? Should they instead just wait so they can document everything? It's ultimate. Well, absolutely, yeah. I call the police; they'll come there and they'll provide attendant medical care. And in fact, Georgia law, if you've caused an accident, requires that you stay if you've injured somebody. So you can actually commit a crime by leaving the scene. And you'd be surprised how many hit and runs there are. Of course, with that being said, I'm also always pleasantly surprised by how many people actually call and report hit-and-run drivers, good Samaritans that have seen accidents happen and have seen cars hit somebody and drive off. I had a couple clients on Beaufort, Iowa, where that's been the case, where the at-fault driver has been identified by just somebody that happened to see a car, collide with another vehicle and run off. So kind of kind of a good thing to know that there's people out there that do the right thing, even when others may not be.
Yeah, that makes sense. So is it ever okay for a person to, like, after they're in an accident, after there's some kind of situation, that they just go back to work or something like that?
Oh, assuming you've called the cops, you've been looked at, and determining what level of medical care you want is, of course, ultimately going to be a personal decision. Just because you're hit doesn't mean you need to go via ambulance, to the hospital. I was involved in a really serious collision when I was in law school, which is part of one of the reasons I do this kind of work. I was T-boned by a large SUV at 45 miles an hour. Ultimately, my vehicle, performed as it was supposed to. My airbags went off and stuff, but I didn't feel that I needed to get in an ambulance. So ultimately, a buddy came and picked me up, and I went to urgent care myself. Other times, obviously, if you can't move or something like that, of course, you're going to go via ambulance. But, ultimately, it's your choice. And some people don't really start to experience serious symptoms in their back or neck until a few days after the accident as their body starts to recover. Because no matter what happens, you're going to be in shock. And that includes your body physically from a muscular standpoint as well as mentally. So you may not be thinking clearly as well. So when in doubt, you can always default to medical care.
Yeah, that actually reminds me. I used to actually work in radio before I went into law, believe it or not. And I was working at a competing radio station not far from here. And I was riding my bike to work that day right here in Buckhead. And I got ran over, smack dab, a SUV rolled over me. And he just left. He stopped. He said, "Are you okay?" And I got up and I said, "I think I am." And then he just took off. And I'm just like, oh my God, what? But I actually went to work that day. I was in a daze, my leg kind of hurt. And as I was sitting in the studio, my knee started to swell. So I think that's a real serious situation. Is a lot of times people don't know they're actually hurt. And then, after a little bit of time, the injuries actually settle in.
Yeah, and you have a little bit more mental clarity about what's just, transpired. And so I think that kind of underscores why it's really important. Even if you don't think you may be hurt, or if you think property damage may not be that bad, call the police and have an accident report done. That's a big first step in getting the process rolling.
Yeah, and I think probably it might be, even if you don't think you're hurt, it might be good just to go ahead and go see a doctor immediately afterwards or soon afterwards.
It can be, absolutely. And a huge part of any personal injury case is documenting someone's injuries, and that is done through their medical care over the course of time. So that's right after the accident all the way through, settlement. Of course, a lot of people need treatment even beyond that point in time. So.
Mm-hmm. Now it's real easy to determine, like, if you're in an accident, like someone hits you, who's at fault here. But how do you actually determine, say you're in, like, the parking lot of a grocery store or something like that, how are you determining, who's at fault, if you're hurt in some way?
Without getting too far down the rabbit hole of basically premise liability law, and kind of going over the basics. So static defects, you have generally two kinds of defects. You have static defects and things like, water spills and things that can be cleaned up relatively easily, right? So static defects, something that's like, it's broken, it's going to be that way. It's not going to be easily cleaned up. And then you have other things that are easily remedied. Most supermarkets and places like that check for those things pretty frequently, or at least they should be. Fault is going to be determined by, like, a variety of factors. There's a lot of standard defenses, like, have you been to a place before? Or have you, it's called prior traverse. So have you, walked through a place, previously? And that is because the law basically looks at, what knowledge did you have and what knowledge did the premise owner have, right? So, and it also depends, the duty of care that's owed to a patron is going to be dependent on, what's the premises. Are you at a friend's house, as a invitee, or are you a guest, or are you an invitee at, like, a large mall or something like that? So the gist is the law basically makes it so that people that own different buildings and premises, are required to keep things in reasonable shape. So if they know that there's a dangerous hazard, or they should have known, and they've not taken steps to remedy that, and a person doesn't have, that same equal or superior knowledge, there could be liability there.
Now, does this go to the same situation as if someone is, like, hurt by someone else in a parking lot? Say, there's a person who's mugged in a parking lot, and, some guy comes up and he's got a gun at your face and he smacks you over the head with the gun and takes your wallet. I mean, a lot of people would think that there's no recourse there.
So negligent security cases are really interesting. They've kind of become more popular in the last few years. And basically what those are rooted in is if you're a premise owner and and you have noticed that there's a lot of security issues on your property, the law basically says you need to take certain steps to prevent things in the future from happening. So there's a lot of ways to look at that. I mean, if there's a lot of crime reports in an area, just because someone's hurt somewhere doesn't mean they have a valid suit. Just like in a slip and fall case, just because somebody slips on some water in an aisle doesn't necessarily mean that, a premise owner is responsible for it. Just the same, if somebody's, held up at gunpoint in a parking lot, that doesn't necessarily mean that the premise owner is responsible for that either. It's ultimately going to come down to a host of very complicated factors. And that's, again, why, soldiering at it by yourself without an attorney can be incredibly difficult, especially in a negligent security setting.
Yeah, okay. Well, let's get into, we don't have to get too far into the rabbit hole, but let's get, we should actually wait a minute. We're coming up against a hard break. You're listening to Lewis on the Law. My name is James Lewis. I'll be your host for the next 48 minutes or so. I have attorney Marlon Rhine in the studio with you. Marlon, real quickly, give them some contact information for you.
Sure. I can be reached at our firm's phone number, 404-410-0037, or I can be emailed directly at Marlon, M-A-R-L-O-N, at therhinelawfirm.com. That's THERHINE lawfirm.com.
Okay, we'll get back into the claim process when we come back. You are listening to Lewis on the Law. My name is James Lewis, and I have yet another awesome, informative show for you guys today. We're talking personal injury with attorney Marlon Rhine of the Rhine Law Firm. Now, Marlon, when we were last talking, we were talking a little bit about some of the situations, some of the circumstances that can occur when a person has an issue in a parking lot or some sort of third-party incident near a business, or, and a lot of people, they would not think that there's an issue at all. They've gotten mugged, and I brought up the situation where a person is mugged in a parking lot, someone's put a gun to them, and they've smacked them over the head, or, God forsaken, something worse happens. What are the type of things that people might, because I probably on first gut, if I wasn't an attorney, would say, okay, I got mugged in a parking lot, I'm filing a police report, I've got a big lump on my head, but there's really nothing else I can do. What kind of things can people look for so that they know to contact an attorney? Because some people won't even know that they have some sort of legal remedy here. I
think one of the first things is if somebody's like seriously injured or seriously hurt, it's always worth talking to an attorney. In the personal injury world, our firm does everything on a contingency fee basis. So a lot of the expenses that may be associated with like a business litigation.
Now, slow down. Sure. When you say contingency fee basis, what are you saying? I know what you're saying, but we've got listeners out here and they're like, what did he just say?
So contingency means that if I don't get paid unless I actually recover something for my clients. So that means I'm going to really vet cases, but it also means I'm going to work really hard for my clients because we're a team from the time somebody comes in until we resolve a claim or resolve a case.
Okay. Now go on. What are the things we're looking for here?
So a big perk here would be, I guess kind of as included in that is that there's free consultation. So, if you see, if you know someone or have had the misfortune of being seriously injured, it's worth talking to an attorney just to see if there's a claim, a case there, because experienced personal injury attorney is going to be far better or far more capable of looking at that and determining it. One of the things you want to look at is if an area is particularly known to not be safe, or if it's known for, having prior issues, like maybe there's been other muggings there, maybe people have been shot there before, maybe there's been a bunch of robberies. And a lot of that you may not know till you file an open records request to get that information. So it's one of those things that, we may not know if there's a case until it's actually been thoroughly looked at, So because it's free, it's always worth reaching out and talking to somebody about.
Now, the first thing most people would say is, well, if I know the place has a reputation, I'm not going to go there. But there was a grocery store on Ponce de Leon, and it had a really bad moniker, the Murder. I'm not going to say its name because I don't want to get sued here.
That's right.
But it was the Murder grocery store, and with a name like that, you'd think no one would go in there. And yet I used to go in there all the time late at night. I needed a pint of ice cream or whatever, and I would still end up going there. So
right, and part of that liability stems from, a relatively recent shift where The law basically says, all right, if you're going to own, a place of business and you're going to invite people to come to it, and you know it's dangerous, you got to take steps to remedy that. If that means putting up cameras or hiring a security guard to monitor the parking lot or something, you got to take reasonable steps when you know that people are getting hurt at your place of business. And again, it's just rooted in this idea that we need to protect the public from these sorts of problems.
Okay, good. So are there other things that people should be looking for, or if we kind of touch, what the main idea of it?
I think, beyond serious injuries, any personal injury case, that's ultimately one big thing you're going to be looking at is, what's happened to somebody. I mean, if somebody's been, bumped on the head and, it was a minor bruising and, maybe they went to the ER, a negligent security case is going to take a lot of resources and a lot of time to resolve. So that may not be something that would necessarily be a fantastic case. I mean, of course, that's an unfortunate series of events, and it should probably be looked at because you just don't know. Because, concussions and traumatic brain injuries can be incredibly complicated, and you may not know for a year until somebody's, lost their job because of it. So it is always worth looking at. But, if it's something relatively minor, like just being scared, for example, is not going to probably bring in the best case. So, whether that's a motor vehicle accident, a premise liability case, or whether it's a negligent security case, that's one of the things we're always looking at is what actually happened. Like how damaging from a financial standpoint has this been to somebody? Have they lost wages? Have they, sought treatment? And what does that treatment look like? And what sort of future treatment are they going to have?
Always looking at the facts, right?
Right, exactly.
Yeah.
Right.
Okay, so now let's get a little into the claim process.
Sure. So basically, we'll take motor vehicle accidents because they're one of the most common, especially from dealing with an insurance.
Everyone's been hit at least once
Atlanta,
or twice.
It's I'll probably see an accident on the way home today. I mean, it's
at least one.
We're a crowded city, and we've got a lot of drivers that are negligently moving about the streets. So going back to what I mentioned about getting a police report, one of the really important reasons to get that is it's going to have both parties' information. The police are going to take the insurance cards from both parties. They're going to jot that down. Now, if the at-fault driver, or if a person hits you and that person calls their insurance company, sometimes that happens. That insurance company is going to immediately reach out to you before an attorney gets involved to try to get as much information out of you as possible. And they'll cling to the statements you make about, oh, well, I feel fine. But as we said, you may not know how you feel, for a couple of days. I mean, it may take some time.
So wait a minute. So what do you do in that situation? Because the insurance company has reached out to you. These guys are pros. They know exactly what to try and get out of you, so they can use it against you.
I think the key is, you can always be respectful. You can always be polite and just say, give them your basic information. You can give them your name. You can, give them your phone number. But most of the time, if you're getting a call from an insurance adjuster, that should, clue you in that maybe it's time to at least speak with an attorney. If you don't have a claim, that's fine. You can handle it yourself. But at least have an attorney look at it. And then, of course, my clients, what I tell them, because usually there's a gap between when I send letters of representation to insurance companies and when they get them, and then, of course, when they're trying to call. And, I always tell my clients, be polite to the adjuster. It's not personal. And, provide them with my contact information so they can get a hold of us, and we'll be happy to take it from there.
Okay. So what is so you've evaluated the case. What's your next step here?
So in the context of like claims handling and stuff, what I always want to do with all my clients is, like in a motor vehicle context, is let's find out what's going on with the property damage claim. I don't take any money to help guide somebody through a property damage claim, and I also don't represent somebody in it, but I'm happy to kind of explain the basics of it. Because, aside from the medical impact, losing your main source of transportation can be a huge problem. How do you get to work? Like, if you've got kids, I had a client recently, they were rear-ended and they've got 2 kids, they work, they rely on this vehicle to not just get their kids around, but, to make money to pay for their house. And so the big thing is getting somebody into a rental car or, and that can be done one of a few ways. That can either be through the at-fault parties insurance company or it can be through your own, depending on your coverage. Sometimes it makes sense to just have your insurance company take care of it and then fight that battle later with the other insurance company, like if it's clear liability. And then in that instance, you actually can get your deductible back. So if you have collision coverage, you're involved, somebody else causes it, and there's some insurance companies that just, they will give people the runaround, for a month while they make a liability determination, even when it's quite clear. And it just makes sense to just tell your insurance company, go ahead and, get us in a rental car, get the claims process started. We'll pay our deductible, And once that other insurance company has made that liability determination, they can your insurance company can then go recover your deductible and reimburse you for it.
Okay, so how I'm going to take my dad as an example. My dad was this old military guy, and
Sure.
And he wouldn't go to the hospital for anything. I mean, he could have cut off a pinky, and he wasn't going to go to the hospital for anything. How important is it to seek medical treatment during this process?
It's hugely important. I tell every client the same thing. The first thing, you want to get good medical care, and then the second thing is building the best case possible. Incidentally, by getting proper medical care, you're actually helping yourself build a case. But, long after a case is gone, and, I've come and gone, if you've got a serious injury, you're going to have to live with it. So it's important to go ahead and get that looked at. I actually really love clients like that don't tend to complain. They make, first of all, they're really, I think, good in front of juries. I think they're also, it's really easy to approach the claim process with an adjuster and say, look, especially with like a military veteran, somebody that, served the country and is, pretty, like my father, is a Marine, and, if he's complaining
those old
about
guys,
something,
they're tough.
I know. He still
they're
goes
tough as nails.
We started working out together recently, and he's on such a routine, and he'll continue to be that way. And they make fantastic clients because they're routine oriented. They're they follow details and pay a lot of attention to them. But
and nobody wants to rule against a vet.
Right, I know, right. And they're folks that just don't complain, and a lot more people come to me with that, I never really wanted to get a lawyer involved, and insurance companies, prey on that approach where most people, it's not, they're set up in such a way that they assume attorneys are going to be getting involved. If you want to handle it on your own, you can, but it's I had a client that came to me recently in a premise liabilities case, and the insurance company offered a very small sum of money, and ultimately we were able to get her 15 times what they had offered her, and those sort of returns on especially more significant cases are pretty common when you have a completely valid case, and it's something that's worth pursuing.
Now, now 15 times, we're up against another break again. This show's going by really quickly, Maybe it's just an exciting topic. Okay, Attorney Rhine, will you give us contact information for you once again?
Yes, certainly. I can be reached at 404-410-0037. Or via email directly at Marlon, M-A-R-L-O-N, at the Rhine Law Firm. That's THERHINE, lawfirm.com.
You're listening to Lewis on the Law. My name is James Lewis. This show comes to you every single week, and what we do is we bring you legal information. If you have a serious legal issue, don't rely on the advice you hear on this show. Go ahead and contract with an attorney. We've got more awesome stuff coming your way right after these messages. You are listening to Lewis on the Law. My name is James Lewis, and I am here with you each and every single week to bring you legal information. This show is designed to only bring you information. If you have a serious legal issue, you need to go ahead and contract with an attorney. You can always contact me at my webpage, jameslewislegal.com, and I may be able to help you with your issue. If I can't help you, I can direct you towards an attorney who can help you with your issue. If you have a legal issue you'd like to hear about on this show, go ahead and drop me a line on my webpage, or you can email me at jameslewislegal.com, james at jameslewislegal.com, or give me a call at 404-610-0075. And if I like your topic, I'll bring an attorney on who actually knows something about your topic, and we'll talk about it on air. Now, I've got another great show going right now. I have attorney Marlon Rhine of the Rhine Law Firm, and we're talking about personal injury. And just as we left, you're saying that you had gotten someone was, let me see if I'm correct, something like 15 times the amount she was actually looking for in the first place?
That she was offered by the insurance company initially, and that amount that they'd given her was basically to just go away. And what's really one of the unique things about our practice is we do pre-suit, meaning we'll make settlement demands to insurance companies, but then we also file suit and actually litigate cases. The pendulum kind of tends to swing, so back and forth from needing to file suit and not needing to file as many lawsuits, and that's determined based on just what insurance companies are offering. And sometimes they want to settle more claims. Sometimes they're not as open to that process, and basically force our hand into filing suits so that that'll just
when
be the way
push
it'll
comes
be.
to shove, sometimes it's better to shove, huh?
Right, and you just got to be prepared to push back, and so we enjoy litigating claims just as much as getting them resolved in advance as well. So
okay, so
yeah.
but that just brings up an interesting point. So
Sure.
you got a large amount over what they offered.
Mm-hmm.
How do you determine how much your demand is for?
So it's actually far more calculated than you'd think. Going back to what we talked about a little bit earlier, your medical damages is a huge component of that. So if you've had $500 in medical damages, there's all sorts of multipliers and stuff flying around on the internet, and occasionally I'll have a client come to me and be like, well, I heard we were supposed to get insert number of times my damages. Those numbers are they don't take into account a lot of factors, and I mean, one very simple one is how would somebody present in front of a jury? So as soon as a client comes into my office, I watch them, walk in. Like I want to see, and as we sit down and talk, I want to look at that, and that's one factor I look at in assessing the value of a claim. How trustworthy are they? And going back to why I like veterans, I mean, typically they're very
if you've got a big military sergeant there with a stiff back and no nonsense,
who don't complain a lot, because, they can be very good clients for a lot of reasons. But nevertheless, so we look at what sort of medical damages somebody's encountered, and those are called special damages. It's the actual out-of-pocket damages that you have, and so there's a lot of complexity when it comes into working through what's called subrogation. And subrogation is when somebody pays bills on your behalf.
Yeah, you used a fancy word there.
Right. So subrogation is basically a fancy word for when somebody pays your bills, whether that's your health insurance provider or workers' compensation or somebody else basically covers the costs and expenses you've had. Oftentimes they can go back and recover those. So one danger in pursuing a claim alone is, let's say you're Medicare eligible and you're in an accident and Medicare pays for some of an accident and you settle the claim on your own. Well, a lot of people wouldn't know how to go and determine what they actually have to repay Medicare. And Medicare or any other federally backed program is going to be able to go, they're going to be able to go and get, whatever monies they did pay out or subrogate against any money that you've recovered. And that also includes certain health insurance plans that are, governed by ERISA, the Employee Retirement Income Security Act. So, if you've got a health insurance plan, through your employer, that can be another thing that we are often looking at. So, but in Georgia, we also have something called the collateral source rule. So what somebody else pays and all of that behind the scenes stuff is not the actual number we look at in terms of damages. What we look at is what full freight would be, at a hospital. So let's say you go to the ER, bills can be varied, but let's just say your bills are, $10,000 at the ER and your health insurance pays, a smaller amount. Well, we have the collateral source rule, which says that smaller amount's not the evidence of your damages, but the actual bill would be. And the reason for that is we don't give the benefit of your cautionary steps and measures to the at-fault party.
So even if you have insurance and your insurance is covering a portion of your medical bills, it's still worthwhile for you to go ahead and seek an attorney to help you actually bring this home.
Right, and it's actually an incredibly complicated process. I have other even personal injury attorneys, and we'll call each other and basically say, hey, have you seen this plan and how they handle it, and how have you seen the plan language? Because a right of subrogation comes down to even actually investigating each individual plan, and on a bigger case where somebody, if somebody's paid out $5,000 or $10,000 and is claiming a right to reimbursement, but of course we'll handle those things, but we want to, make sure that it's a valid right. I don't want to just, give somebody $10,000 because they sent me a letter and said, they're entitled to it. I want to see the backing for that. And the reason is to protect my client's interests, because ultimately that's obviously what's most important. So, we request that plan language. We'll go through it, and we want to make sure. And like I said, it can be rather complicated.
Okay, so during your negotiations, is there a process here in your negotiation?
Absolutely. So kind of going back to how we establish damages a little bit. So you have your medicals, you got your lost wages, and what we'll do is we'll put together like a really lengthy and detailed demand letter. I use it for litigation planning. So I'm going to go ahead and request, records. We're going to get everything lined up, and I'm going to come up with a figure that's reflective of the damages I mentioned, lost wages, medical expenses to date. Then, of course, we're also going to build in, pain and suffering, future medicals, any permanent disabilities, anything like that may be in place. And so what will ultimately happen is I put together this demand package that's, contains this letter as well as all this supporting documentation. I send it to the insurance company. And if we're demanding it from a liability carrier, they have 30 days to respond. Usually they'll respond somewhere in that time frame towards the end. And, typically what will happen is an adjuster will call with an initial offer. And from that point forward, the negotiation process begins. And, we want to look at, what's owed to medical providers and what's owed to other parties. And what can we actually resolve the claim for in a way that ultimately maximizes what my client's going to get out of it.
Okay, so now we're in the situation where your demands have fallen through. The insurance company's just not going to pay. Let's talk about the litigation process.
Sure.
Now, this is the exciting part of law. This is when people
the fun part.
Yeah, when people think of lawyers, that's what they think of. They're like,
right.
"Oh, you're your courtroom attorney." Everyone thinks. I think our video producer asked me for some courtroom shots. I should have told him. Majority of what I do all day is I draft documents.
Sure.
I draft and review documents. Not quite as exciting when you think about an attorney, but litigation. So, what is the litigation process?
So, once we've reached a sort of impasse with an insurance company, when we've realized that we're just taking two different positions, we just file suit. And the way that typically functions is, I have a conversation with a client, because it is a lengthy process. And frankly, I think, being willing to enter the litigation process is something that takes a lot of bravery, because it's going to take a lot of time. There's a lot of financial burden. A lot of people don't know, but
it's a lot of work.
It's a ton of work. And like I said, from day one, a client and I, we're on the same team, and we are team members moving forward together. And, a lot of people don't know, but they have to shoulder the financial burden as well throughout this process. And so, of course, insurance companies are aware of this, and they design the process to be as lengthy as possible to stretch people as hard as possible. So when somebody's actually willing to go through with the litigation process, like I said, I view it as very much an act of bravery, because, it's not always easy. But, of course, with
there's no guarantee either.
There's never a guarantee. But with experience, of course, has come, the ability to at least try to guide people as effectively as possible. So when you're actually ready to file suit, I draft a complaint, and that's how you initiate a lawsuit. You determine the venue, you determine the defendant, and with this complaint, you file it in the appropriate county, with a summons. And I typically serve, most of my complaints. So once you send it to the court, they send it back a stamped copy. You get that, you send it to a process server, and this is something that people, sometimes will see on TV. And I actually love this process server that I've been using, because he's really he's very good. And, he'll send me funny texts or emails that'll say, I'll send, request a little update, and he'll say something to the effect of I wasn't able to find him. Got to do a stakeout. And so he'll go find people and give them a copy of a lawsuit, and it'll contain what's called discovery, which are requests for productions of documents and requests for admissions and interrogatories. So basically we're asking, just questions and asking for documents, related to the accident, so we can move through the litigation process.
Okay. When we get back, we're going to talk more about the litigation process, and we'll get into some damages here. But I want to give you a chance to give them a little contact information for you real quickly.
Sure. I can be reached at the Rhine Law Firm. My phone number is 404-410-0037. You can also be emailed directly at Marlon, MARLON, at the Rhine Law Firm, THERHINE, lawfirm.com.
Okay, you're listening to Lewis on the Law. My name is James Lewis, and I am here with you each and every single week. And, we love to help empower you, the listener. That's what this show is all about. We bring you information. You can go to my website, and I have cataloged all my old shows on my website. Eventually, there'll be almost every single legal issue that you can actually think about cataloged on my website. And you can go there on the show page. You'll be able to just look at my old shows and talk and look at the issue that you're interested in. If you have a legal issue, you can go to my contact page, drop me a line, and let me know what your legal issue is, and I'll try and bring an attorney on who actually knows something about your issue, and we'll talk about it on air. When we get back, we'll have more with attorney Marlon Rhine of the Rhine Law Firm, and we'll be talking damages. You are listening to Lewis on the Law. My name is James Lewis, and I am here on the air with attorney Marlon Rhine. And Marlon, will you give them some contact information for you? Because you are a personal injury attorney yourself, right?
Absolutely. Yep.
Yeah. So if you're involved in an accident, if you have this kind of issue, Marlon would be a great guy to get in touch with. So how do they do that?
Yeah, we're happy to talk with anybody that's looking at an issue, and we can be reached at 404-410-0037, and I can be emailed directly at Marlon, M-A-R-L-O-N, at the Rhine Law Firm, THERHINE, lawfirm.com.
That is awesome. Okay, Marlon, when we were last leaving, we were talking about the litigation process, and this is the exciting part of law. This is what everybody thinks of when they think of an attorney. They don't think of some stodgy, middle-aged, chubby dude like me sitting there reading commercial leases or, putting your closing disclosure together for your home sale. Okay, so where are we in the litigation process here? You filed the paperwork. What's next?
So basically, once it's been filed, once it's been served, most of the time I'm going to serve discovery, which, like I said, is a bunch of requests for documents and questions for somebody to answer. They'll have 30 or 45 days to respond to the discovery. And typically what will happen is we'll also forward a copy to the insurance company, and that insurance company is actually going to appoint defense counsel to somebody. That's part of what you're paying for when you have an insurance policy, is representation in the event that you're sued. So what will typically happen is we'll get like a call or we'll get a response back around that 45-day deadline. Of course, it's 30 days if we don't serve discovery at the same time. What will most often happen is once counsel gets involved on the other side, they're also going to send us the same, which is a stack of discovery and questions and requests for our client to provide a bunch of documents. Of course, if you ever hit somebody and it's your fault, you don't want to avoid process servers, and you basically want to contact your insurance company as soon as you get those documents. Because in addition to my sending a courtesy copy, you also want to cooperate with your own insurance company. Because at the end of the day, accidents happen. I mean, it's not like anybody's, these scenarios happen all the time. People are served every day, and people receive, these sort of requests all the time. So as we start to go through the discovery process, which lasts for 6 months, what will also be done is depositions. So we'll go through, once we get all those requests and questions from a defendant, we'll go through those with our clients and make sure they're answered, and we'll send them back. And typically we'll also sit down with opposing counsel and get a deposition on the calendar of our client and anybody that we wish to depose. So like in a premise liability case, that's typically going to be a 30B6 deposition of a corporate representative. In a standard auto accident case, it's going to be the deposition of the defendant or the person that caused the accident. And depositions, kind of like being served with process, happen all the time. I think oftentimes people hear that and they can get a little concerned. But very basically, if you're ever involved in a deposition, tell the truth. It's easier. You don't have to remember anything. And also, just don't talk too much. Just answer the questions asked of you.
Now, do you actually coach your clients in depositions, or do you before the deposition?
I wouldn't say coach, but I try to go over some of those very basic things. And like I said,
you wouldn't say coach?
No, I will, because at the end of the day, I just want somebody to be honest, and the facts are what they are. It's just our job to get those facts out there. And if we've worked, typically we've worked a case up, and I won't generally file suit on something unless I feel pretty comfortable with it. And when that is the case, it's just a matter of getting those facts into the opposing party's hands, and they're going to come out eventually. There's no big gotcha surprises at trial, generally speaking, like on television where someone just comes running in with something that's like, I got a document here that shows that they were been drinking. It's like, no, we're going to know about all that stuff way ahead of time. And just the same, I mean, but
that's the exciting part of the TV show right there. That's the moment.
Yeah, absolutely, and it makes for a really good TV. Unfortunately, the law grinds at a much slower, boring pace. However, once the deposition process is concluded, and there's generally you're taking discovery depositions, which means that they're non-evidentiary. There's not a lot of objections, generally speaking. And once discovery closes, then, we start getting something set for hearing. Now, one thing that has occurred in the last, my understanding is 10 to 15 years, is the advent of alternative dispute resolution. So while that is contained in a lot of contracts, which I'm sure you're aware of as a contract attorney, arbitration provisions, often limit, cases going to court in certain circumstances. There's not a lot of arbitration provisions in insurance contracts, so what we more often see is mediation. I mean, sometimes we can mutually agree to go to arbitration. We could do like a high-low arbitration, which is where
now what's the difference between arbitration and mediation?
So arbitration is when a binding opinion is actually going to be rendered by a chosen arbitrator. Arbitrator.
That's right. Yeah.
It's a weird. Yeah.
Yeah.
So in that circumstance, there's actually going to be an opinion and it's binding. In mediation, it's basically where the two parties come together and say, hey, let's see if we can work this out. It's pretty effective. There's a lot of mediation companies, in the area that we've had good luck with, and it can be a really useful function for a multitude of reasons. And I've had recommendations for mediation come at different times in the litigation process. Most often it comes, when discovery has either finished or is going to finish shortly, and after like depositions and after discoveries.
Now, is it the judge who'll make a recommendation for mediation?
They can. I mean, there can be court order mediation, but oftentimes it's both parties. And this will be like after depositions. And like I said, the facts are what they are. So once both sides have the facts and they know what they are, it's often a good time to sit down at a table and say, this is what it'll be. Yeah.
So how does that work? Do you reach out and say, hey, I think we should go to mediation?
It can be. I mean, sometimes if we're going to ask to be set for like a trial and put on a trial calendar, what we'll say is, hey, we're going to do this. Would you rather, try to go into mediation first? And depending on when a mediation occurs within the litigation timeline, it can be a really useful tool for even getting ahead of some of those depositions. I had a case recently where we went to mediation before depositions, which saved both sides a lot of money. We were going to be getting into a battle of experts, and of course, the other side gets a little bit of a discount because of where we're settling. But of course, our client also doesn't have to go through this significant process, and more of their money isn't being eaten up by fees and expenses.
So even if mediation costs some money, it might actually be cost saving in the long run.
Absolutely, it can be, especially if there's experts involved, or you're going to have to take a bunch of depositions of corporate defendants, or even just defendants in general, because all those things cost, and they do ultimately come out of a settlement. So even though our clients aren't shouldering that burden initially, and we're basically providing that up front, of course that's something that on the back end they do have to pay for. So it's a cost savings mechanism for our clients as well.
Okay.
Yeah.
So it's all gone into the proverbial crapper, and now you're looking at damages in the case. So you've spoken a little bit about special damages. What are the type of damages that are available?
So there's also general damages. Those are the two big splits. Special is going to be what sort of out of pockets you've actually incurred. General is going to be things like pain and suffering. It's going to be like future medicals. It's stuff that you will incur, but it's not an actual out-of-pocket expense.
Now, do you have to have special damages to get general damages?
I've never thought of that. The short answer would be no. I think it'd be unusual to not have that be the case, or to have that be the case. And I think one thing that you always kind of want to...
Now I was just thinking about that because we had a question from the audience about PTSD.
Sure.
So, sometimes there may not be any special damages, but a person has suffered a lot of trauma. So
in the instance of someone that's any accident of any kind is going to cause some level of trauma. And when you have really severe trauma, a huge part of that is going to be documenting it, explaining it, and trying to substantiate it. So as a part of doing that, you're going to generate special damages because you're going to need to go to a neurologist, or you're going to need to go to a therapist, or there's going to be because if it is that bad, you need to seek help, right? So if you haven't sought help, but you're claiming it's really bad, that's going to be a problem.
Okay.
You can't just say, my back hurts. It's so bad. I can't work. I can't do anything. Well, but if you haven't gone to a doctor in a year, why is that? I mean, didn't you think maybe getting help was a good idea? And that's going to be, of course, the insurance company's position.
Okay. So they kind of more or less go hand in hand.
Often. Yes.
Okay. Yeah. So let's get more into general damages then. What are the type of things are there included in general damages?
So when you're looking at like pain and suffering or future medical, pain and suffering is commonly heard of. That's basically to compensate you for things like, the stress of the accident and some of the challenges you've been forced to incur by going to a doctor and all these sort of issues. And I always like to talk a little bit about, permanent partial disabilities. Sometimes when someone's had a really serious injury, they deserve to be compensated for the diminished capacity that they have. So if you, for example, broke your left hand, it may never fully heal. It's always going to be slightly weaker. You may always, or if you've broken like chipped a tooth or something, you may always have an apprehension, in terms of biting. So whereas like with a chipped tooth, that may be more of a pain and suffering issue. In the hand, we can actually measure that diminished capacity. And so there's the American Medical Association publishes a set of guidelines for impairment ratings, and you can actually take that and extrapolate and put a financial value on what that loss will be. So let's say it's 5%. To the whole body extrapolated from that limb. You can look at that over the course of 5% per year for the rest of someone's working life, and you can actually try to take and put that into a number.
And I think there's a lot of stuff on damages that we're going to leave on the table here. Yeah, our time just kind of ran out. This was a great show. Thank you a lot. Thank you a lot, Marlon. Once again, give them some contact information for you.
Yeah, sure. Well, thank you again for having me on. I may be reached at the Rhine Law Firm, which our phone number is 404-410-0037. I may be reached directly via email at Marlon, M-A-R-L-O-N, at the Rhine Law Firm, THERHINE, lawfirm.com.
You're listening to Lewis on the Law. We'll be back next week, and we have the city of Atlanta coming back, and they'll be talking about traffic violations, especially the new seatbelt law, or the new hands-free law. See you next week.